Hello and welcome to the Silver Shemmings Ash Construction Law Podcast. I'm Sean Lowthorpe, a business journalist, and I'm joined by two of the firm's construction lawyers, partner Henry Hathaway and associate Lachlan Steer. Thanks both of you for joining us. In this episode, we're going to discuss issues around third-party rights and collateral warranties and what you need to know. Henry, I'm going to start with you. In very simple terms, what are we actually talking about here?
Sean, in any contractual relationship, especially we see them so predominantly within the property development industry, whereby we will have a fund, we'll have future purchasers, first purchasers, tenants, and they want to benefit from what is actually going to be built in the future. We have a developer, and we have a contractor, maybe some subcontractors or designers. And all of these parties in together all have contractual links to each other. What happens is that, and under the rules of privity, as we call them, is that only a party to a contract can enforce the terms or sue on those terms specifically. So therefore, the common problem arises. If that we have a contractual relationship between a contractor and subcontractor, which has benefited or provided something to the development, we want to know, can the fund or eventually the tenant actually benefit from those provisions of that contract?
And your take on this, Lachlan?
My take on it is it's a key part of the contract process. As Henry said, there are plenty of people who aren't immediately in contract as the place is being built or tasks being undertaken. So it's vital for, say, a tenant who eventually ends up in the building to be able to have a course of action. Without these third-party rights, they simply won't have a standing to bring a claim. So what this really does is it puts minds at ease and actually gives people a course of action, be they, as we said, purchasers, tenants, or potentially funders.
There's always been a chain, though, I suppose, within any kind of construction sort of deal. Is this all new? I mean, what's the background of this?
The rules on privity have been in existence, really, and confirmed by the House of Lords back in 1915, Sean. So it's quite an old position or doctrine. And while the rules of privity actually seek to protect two parties from being sued, if you like, from an outside stranger to the contract, it has the limitation by which other parties who would like to take the benefit from that contract, it's quite restrictive in that sense. The purpose of third-party rights, the purpose of collateral warranties, is to actually confer the benefit of that contract so that they can enjoy it. So, a practical example. In any given construction environment or development, we will know that a subcontractor will provide services by way of contract to a contractor for the provision, say, of cladding, say the provision of waterproofing or whatnot. They are then, it's ultimately going to be those at the top of the chain, the fund, the tenants to which the provisions are made for, that want to enjoy that benefit later on.
When would you get involved in this, a discussion around this topic? I mean, is it, again, as we discussed elsewhere, something that you have to think about at the start? Is it something that kind of pops up when people think about it? I mean, just walk me through that a bit.
Well, it's a very good question. As ever, we'd say we'd like to look at projects in a prospective way. And by that I mean when we're dealing with the amendments to a contract and all of the what we'd call ancillary documentation, of which a collateral warranty is one example, that would be dealt with at the same time. And traditionally what you'd have is effectively templates for the agreed forms of third-party rights, collateral warranties, etc., that would be annexed to the contract, and you'd have all of those terms agreed at and or around the same time. Now, of course, that's not to say that always happens, because quite often we'll get people in a panic saying, I'm not sure I ever actually signed my contract, I don't know what we agreed as to collateral warranties, etc. So it's much better to have it all sorted from the outset, but not as common as we'd like.
I mean, just sort of touching on that point, I just wonder what are the kind of problems or issues that crop up when you start thinking about these sort of third-party rights or collateral warranties. I mean, what's the sort of typical kind of scenario of when it sort of starts to bubble up?
Well, I think that the first aspect is to actually return, how do we actually confer those benefits and what are the mechanisms? Principally, we have the 1999 Act, which confers a third-party rights. And we have a number of different sections, but very simply, if a party or a class can be conferred the benefit expressly in the contract at the start. So therefore, if we think of a development agreement between a fund and a developer, they may want to confer or ask for those rights to be conferred expressly. We want benefits in that stated amount. Another format is collateral warranties. The main problems that we would see is just the understanding, the privity rule and what contents go into these. Then furthermore, we actually have to address when do we actually procure them, the problems we face with them, because they can be quite extensive.
Collateral warranties. I just want to sort of dig into that a little bit more about what we're talking about. I mean, there was a suggestion that that's a kind of more secure type of agreement than maybe third-party was. Is that right? Can you explain that?
Well, it's a good question, and the answer is actually no. It's more in the minds of people that they prefer a more detailed document. If you're talking about, on a strict analysis, the actual rights and obligations, well, the rights anyway, the obligations we'll come on to because, of course, collateral warranties can be far more detailed, but the rights were transferred in the same way. So they confer the same benefit, but collateral warranties can be more reinforced than third-party rights.
I think an awful lot within the construction industry at present is habits. Third-party rights have been there since 1999. There is a predominance in the construction industry to use collateral warranties, and a lot of it forms by habits. The funders might be somewhat wary because they're concerned about, say, step-in rights that they might enjoy. But we do have, it's more habit, Sean, I think, and that's where it actually rises. But in certain instances, third-party rights can actually give more direct by providing a notice, and it can be that much more streamlined. So there is a chance and an opportunity for the construction industry actually to adopt these in the future.
Are there any other sort of problems that arise here that you see that sort of come across your desk when perhaps things haven't been pinned down as well as they could have been?
Well, plenty, sure, frankly. One of the key aspects to our job day to day is to look at documents and to check, well, what's their status? Have they been properly executed? Do the documents confer the rights and obligations that the parties think they do? Often they don't. And so in terms of collateral warranties, one key aspect to this is, well, who has signed it? Does it matter who has signed it? Does everyone have to sign it? The answer is, well, as long as the person conferring the right has signed it, that's fine. The beneficiary need not actually sign or execute a collateral warranty, and that's something that sort of trips up people. They think, oh, well, this hasn't been signed, but actually no, if the person conferring the right has signed it, then that works. And there are various other clauses which, Henry, I mean, we encounter problems all the time, don't we, in terms of drafting of these documents?
Yeah, and I think one of the main key points that when we're asked sometimes by contractors or those other parties to review the contents of a collateral warranty, for example. And all we're ever given is the actual collateral warranty. The collateral warranty, what's very important to take from this, is a collateral warranty has an instrument behind the actual underlying contract. And we need to look into the details of that, and we actually need to see what rights are being conferred. So it's a whole bottom-up, top-down approach.
Well, I was just wondering about that. I mean, if you've been called in to look at this, I mean, what are the sort of main points of negotiation then that you're trying to sort of tease out or to seize upon? And also, is it something you can sort of retrospectively alter, or is it a case of when it's signed, that's it, you can't change it?
Well, I think that in the event that our client is a developer, for example, the biggest issue that we find is that we can amend and we can make express provision through amendments of that contract to ensure that we have procurement and delivery of those third-party rights, be it collateral warranties or otherwise. It's what happens down the chain. And where there might be many different subcontractors, it's actually procurement and delivery from down the chain. That is one of the largest issues. It becomes an issue usually for the contractor, and the contractors do have quite a number of different issues in those points.
It's a topic, isn't it, that you cover in the breakfast seminars. and is particularly well attended, actually. I mean, it is technical, but I just wonder what it is that people are hungry to know about when you present these topics.
Well, I think there are several what I term flashpoints in terms of the clauses in collateral warranties. One classic example would be a net contribution clause, and what that seeks to do is to limit the individual liability of the person conferring the rights, the person giving the collateral warranty in the context of the project as a whole. So that individual is clearly going to want the clause. An employer or main contractor is not going to want the clause because that liability is being limited. So one of the first things Henry and I would look for is that clause. And there are several other key clauses also.
Yeah, exactly right, Lachlan. And we generally, Sean, spend quite a lot of time looking at the insurance provisions, especially when there's maintenance of insurance for either 6 or 12 years, generally 12 years on those points. The biggest key aspect of that and to take away from is that what the insurance provisions of the underlying contract and called for in the warranty actually matches the policies that the company may have in place that's conferring the benefit and providing the benefit. It's always very clear that they must keep very close contact with their insurance provider as well. So done correctly, this becomes all parties that must actually assist in this process to make sure they are actually insured for those points. We've come across a number of different instances by which the limits of indemnity have not been agreed, or that they do not in fact match what the actual party is insured for, and that can lead to quite numerous big problems in the future.
I think on a sort of higher level, it's merely a question of making sure that a flow down of the relevant rights and obligations has occurred, be they insurance related, be they design responsibility related. One of the key areas for us is certainly to make sure that the obligations on the contractor in terms of their workmanship haven't tried to be upgraded in the collateral warranty. So what we'd come across generally is reasonable skill and care, that being the standard to which the contractor is held. However, some unscrupulous individuals may seek to try and obligate the contractor to provide a fitness for purpose to their works in a collateral warranty, and that should be avoided at all costs from the contractor's perspective.
So is this a collateral warranties then? Is that something you should always sort of take out insurance then to cover? Is that the typical process?
Well, the insurance actually comes from the underlying contract, a primary agreement between the two parties. So think of a collateral warranty as conferring the right of that contract onto the beneficiary. So what we're looking for is a like-for-like position, and that they maintain the insurances and that they understand. And certainly in other podcasts and other breakfast seminars, we talk about insurances. We find generally that there is quite large problems within the industry as to how they understand how insurance works. So there has to be a like position that it's actually supported. But the main problem that we generally find is that when we get to the actual procurement, parties find it very difficult in the industry to actually procure those collateral warranties in the first place, because we get into a situation where subcontractors have moved off or they've gone, and to try and retrospectively get that in place. We're also asking parties to enter into, effectively, another contract. You can't force another party into a contract. It doesn't make sense. So it's by good drafting on behalf of developers or looking at the fund agreements to make sure that it expressly is a requirement that the parties down the chain actually have obligations to procure, and therefore that there is an adequate sanction, if need be, in the event that they don't.
So everything sort of starts with the developer in the chain.
The fund and because they will be the beneficiaries.
Yeah. So what are the limitations then of collateral warranties? I mean, are there any?
I think one of the biggest problems that actually occurs is if they are not executed correctly. I think that is one of the largest risks. And when we get to the point of what the actual details that are required, we've often come across problems, and Sean, we've often seen where we have taken documents late in the process. We've been asked to review. We'll be in contact with other law firms, and then we see a system whereby we have couriers racing all over the UK trying to get them re-executed, and it can occur. The principal point is the copies in wet ink is a common aspect of Lachlan, and then clearly as well, we've also seen where parties have dated it before the beneficiary. These can be all common things that can actually create problems to getting agreement for leases completed. All of those problems can occur.
It may well be that proper execution of collateral warranties is what's known as a condition precedent onwards for another action, i.e. everything has to have been properly completed in order for the next stage to be moved on to. And on top of the things that Henry has just mentioned there, I'd also add that I've seen in the past manuscript or amendments by hand to these documents. Now, if your collateral warranty is a deed, it's simply not good enough to strike through the word and make your correction. The deed has to be corrected as a deed, and I think people in their rush to get things across the line have occasionally fallen foul of this. Well, I say occasionally, it's probably more frequent than we care to admit, but again, it's making sure that people take care with the whole process, and particularly with the amendments if rushed and done by hand.
You were sort of correcting me earlier when I was kind of making this kind of simplistic comparison between sort of third-party rights and collateral warranties, and you know, is one sort of preferred rather than the other. But I mean, we've talked about those two sort of mechanisms. Are there any others that people might use or adopt in situations like this, or is this really what we're talking about?
There are two principal mechanisms. Again, we say that, like especially in the construction industry, collateral warranties still have a predominant point as why they're more popular, and habits are one of the main chief reasons. There's always been an issue surrounding why funds don't particularly like third-party rights under the Act. There always has been concern with step-in rights, as we would call it, the ability for the fund to step in on a specified event to complete. But realistically, good drafting can overcome that, Sean. Now, what we say and what we think, and having dealt with both so regularly, is that third-party rights do have quite a good future. And JCT has taken into account of it. And it's very much it's a paradigm shift for many people to change their habits. The aspects that can go wrong with collateral warranties, the ability to procure them, the ability to have all of these things brought together at the very end, can cause difficulty. In the alternative, where a beneficiary or a party to can actually issue a notice under the third party right, that can make it a lot more simplistic.
When would you need a bond?
Well, that may also be a further requirement in terms of what we'd call project security. So you may have to give collateral warranties, and then you have bonds and potentially guarantees as well. I did once come across a parent company bond, which of course is a complete nonsense, and we laughed the person out of the room that brought that to us. However, bonds, principally there are two types. There are bonds of guarantee and there are on-demand bonds. And it's essential for our clients and for everyone involved in the industry to understand the difference between them. An on-demand bond can be called, as suggested, whenever the beneficiary wants, whereas a bond of guarantee, there must be a trigger point. And so to understand which bond you're signing up for really is the first step in deciding whether it's right or wrong for you.
I think that especially, like, there's so many different forms of bonds, and I think the recent events as well of Carillion has certainly brought certain bonds back into the forefront. Retention bonds would be a very good example, but as I said, with performance bonds, and certainly with the different forms, we're actually seeing more of a prevalence at the moment in certainly being asked for as a requirement.
Simply because people are looking for, like you say, the security and the guarantees.
I think, sadly, it's a bit of a tick box mentality. You know, how can I ensure that I've got as much security as possible? Have I got my warranties? Have I got my bonds? Is there potentially even a parent company guarantee? You know, these are the questions that people are now asking themselves and taking things very seriously after events such as the collapse of Carillion.
I mean, who should people go to find out about these different instruments? Is it pick up the phone, talk to you, come to... I mean, what should people be doing?
Well, ultimately, we would provide information and we'd certainly provide advice when it's called for, either under your underlying contract or if they simply want to know more about it. There are specialists in the market, bondsmen. What we would always recommend is that companies look at who is underwriting the bond, essentially, and the quality, the AAA rating, as we say. But when it comes to the wording, the obligations, the key point is to understand what performance and what obligations, because in some respects there's a performance guarantee based on the performance of the contract, that in the event of a default on that those bonds can be called upon.
Can I have some final thoughts from each of you on this? I mean, this is a complicated subject. I mean, it's all complicated, I suppose, but we're talking about sort of legal and financial instruments here. But I mean, your kind of, your one takeaway that you would say to somebody who's listening to this, look, I mean, if they've got a question about this, I mean, what do they need to think about?
I'd say get everything sorted from the get-go, at the outset of the project. Easier said than done, and easy for us to say, but that really is going to make life much easier.
Yeah, I think that's right, and I think an early start in all of those points, especially in relation to third-party rights or collateral warranties, the importance of them, because it allows for completion of an agreement for lease, for example, and it can be a condition precedent, as Lachlan mentioned earlier on, in relation to a fund agreement, and they are just as important as the actual construction works themselves, and they're not to be left to the very end. Also, I think that the insurance points need to be also addressed and really understood.
Okay, well, we're going to have to leave it there. So again, lots to talk about and lots to think about. So if you want to find out more or get in touch with either Lachlan or Henry or a member of the Silver Shemmings Ash team, then go to the website. That's silverllp.com. And don't forget those breakfast seminars too. Once again, thank you to our contributors, Henry Hathaway and Lachlan Steer, and thank you for listening.